Good afternoon. My name is Paul-Jean de Cannu. I am a team leader and legal counsel at the International Center for Settlement of Investment Disputes, also known as ICSID. Before I start my presentation, I would like to thank the organizers of the event, and in particular Vladimir Kozin of the UNODC, and my distinguished co-panelists, Professor Jarek Krivoy and Dr. Louis Iliamzon. I am sorry I could not attend in person for this important conference, but I hope that my brief presentation, despite its somewhat unusual format, will be of some use to today's discussion. So I will try in just a few minutes, first to explain very briefly what ICSID is, and secondly to give you an overview of the kind of issues that have arisen where there have been allegations of corruption in ICSID cases. Now, what is ICSID? ICSID is a dispute settlement mechanism created by an international treaty referred to as the ICSID Convention. It is one of the 5 institutions of the World Bank Group that you see on the screen. While most of the other institutions have a financial role, ICSID roles focuses on providing arbitration, conciliation, and mediation services to resolve disputes between investors and states. ICSID is actually the only institution that was specifically created for that purpose, and it administers the majority of investment cases. ICSID is designed to provide a neutral and impartial forum that ensures a balance between the interests of the states on the one hand and those of the investors on the other. It is a self-contained system with a simplified enforcement mechanism and its own post-award remedies, including annulment. Now, the institution has a global reach with its 154 member states. The majority of disputes brought to ICSID are based on investment treaties. That's 76% of cases. Disputes are also based on domestic investment laws, 8% of the cases, and investment contracts, 16% of cases. So these are the 3 bases of consent to ICSID arbitration: investment laws, investment contracts, and investment treaties. Let's now briefly look at the notion of corruption in the ICSID Convention and international investment treaties. The ICSID Convention itself does not contain any definition of corruption, and there is only one express reference to corruption in relation to the annulment of awards. A party may request the annulment of an arbitral award on the ground that there was corruption on the part of a tribunal member, and this annulment ground has never been used. Now, if we turn to investment treaties, a fair number of them contain an express legality requirement that the investment of the investor has to be made in accordance with the laws of the host state. In more recent treaties, you will find a variety of express references to corruption. For example, the need to combat corruption in the preamble of certain treaties, which may include references to the UNCAC, or, for example, an express prohibition on arbitration claims by investors where the investment has been made through corruption. Now, let's have a look at the issues arising out of allegations of corruption. There have been cases where the host state has alleged that the investor committed acts of corruption when it made its investment, acts such as the payment of a bribe to a state official. There have also been cases, although fewer, where the investor has alleged that it was asked by a state agency to pay a bribe and was the target of retaliatory acts as a result of its refusal to pay the bribe. Now, where corruption is raised by the host state, it's often alleged as a defense in the form of a challenge to the jurisdiction of the tribunal. In ICSID arbitration, in order for a tribunal to have jurisdiction under the convention, certain requirements have to be met, which you can see on the screen. There has to be a legal dispute between a national of a contracting state and another contracting state. The dispute has to arise directly out of an investment, and there has to be consent in writing to ICSID arbitration from the disputing parties. Now, as I said earlier, consent to arbitration can be given via an investment treaty. The host state, makes an offer to investors to arbitrate investment disputes in the investment treaty, and that offer in turn may be accepted by the investor in writing, and we have consent to arbitration. Now, tribunals have addressed the impact of corruption with respect to jurisdiction from different angles. If the investment was made through corruption, was there an investment within the meaning of the ICSID Convention? Or was there valid consent to ICSID arbitration, where the investment treaty, so the instrument of consent, provides that the investment shall be made in accordance with the host state laws? Another defense we have seen as well in cases is to argue that the claims should be dismissed on the ground that corruption is contrary to transnational public policy. Now, in cases where corruption has been used as a sword, as a basis of a claim by the investor, if you remember the bribe refusal scenario that I just mentioned, in that type of situation, tribunals may be called to determine whether a request for a bribe by a state agency is a violation of the fair and equitable treatment obligation owed to the claimant investor pursuant to the investment treaty. This question has been answered in the affirmative in the case in which it was raised, but in that case the claimant also failed to offer clear and convincing evidence of corruption, which actually takes us to another issue, proving corruption. There are several issues. First, where there are prima facie grounds for suspecting corruption, is it the tribunal's duty to investigate the facts sua sponte? Secondly, as tribunals have noted, corruption is difficult to prove, and it's also a serious allegation. So while some tribunals have demanded clear and convincing evidence of corruption, others have opted for the preponderance of the evidence standard. They have looked for red flags, i.e. indicators of corruption, circumstantial evidence to establish corruption. Now, if corruption has been proven, tribunals have to address the consequences of a finding of corruption. In cases where the respondent state successfully raised a corruption defense and the investor's case was fully dismissed, either because there was no lawful investment or because there was no valid consent to arbitrate, some commentators have identified a potential asymmetry in view of the bilateral nature of certain corruption acts. While the investor's claims are dismissed in their entirety, should there be any international responsibility on the part of the state for acts of its public officials? Should the state be required to prosecute the officials who took the bribe from the investors or those acting on their behalf? Our co-panelist, Dr. Liamson, was, I think, the first to explore this issue in depth. Now, some tribunals have appeared to address this issue in the allocation when addressing the allocation of costs. Some tribunals have split the cost equally between the parties, taking into account the fact that the state participated in the situation that led to the dismissal of the claims. Another tribunal urged the host state to make a substantial donation to a United Nations anti-corruption fund, failing which the state would be held liable for the cost of the proceedings and 75% of the claimant's legal costs. Now, to conclude this brief presentation, I would say that while the case law on corruption is still developing, cases suggest that investment arbitration, can be a tool, one tool among others, to address corruption, and has the advantage of offering an efficient enforcement mechanism to combat corruption. Thank you very much.